You're going to feel for everything that's now inside that. Your honorable Michael J. County.
Good morning. Okay, got some. We have a lot of arguments by Zoom today, so don't think that the indication in this courtroom is that we're only hearing a couple of cases. But on behalf of myself and Judge Kelly and Judge Mariani, welcome to our Grand Rapids case call. We're panel number 7. I know that there are familiar cases on our docket today, and we know how important these cases are to the litigants. So I can assure you that we've been diligently working on these matters over the past month, and we've had the benefit of your briefing as well as the work of our chambers. So we're familiar with the relevant facts and also the pertinent law. So I'd ask you to focus on your salient points, keeping in mind our role as an error correcting court. For those that are new to the court, just a couple of rules. If 2 sides are endorsed, you each have a half an hour. Please don't feel the need to take it all. And if one person is endorsed, you have 15 minutes. I'm happy to keep your time for you. And if I mispronounce a litigant's name or an attorney's name, please correct me. Believe me, Annika Letica has been pronounced in many different ways over the years. So with that, we look forward to hearing your arguments, and we'll begin by calling item number 1, docket number 367-952, people of the state of Michigan versus Seth Therese Lipscomb. And I believe that is our first Zoom argument. Do we have Mr. Roach? All right, Mr. Roach, you're the only one that's endorsed, so you're free to go ahead.
Good morning, Your Honors. John Roach, appearing on behalf of defendant appellant Seth Lipscomb. I'd like to thank the court for allowing me to appear by Zoom today, and also apologize. I was a little late in getting the exhibits that the court had requested, and I believe they were finally all submitted last week. And I'd like to thank Ms. Arnold and Mr. Sanford from the Berrien County Prosecutor's Office for getting those to me so that I can forward them to the court. As it relates to Mr. Lipscomb's appeal, Your Honor, we would rely on the brief presented. I don't have any new case law or facts to present the court this morning. We would, again, rely on the 3 issues I presented, as well as the 3 issues that Mr. Lipscomb presented to the court as well in his pro per supplemental filing. I'm here this morning to answer any questions that the panel might have regarding his case.
I don't have any. Not for me.
All right. It doesn't look like we have any questions for you. So thank you so much for appearing today. We appreciate it. And this matter is submitted.
Thank you, Your Honors.
With that, we'll move on to item number 2, docket number 370642, people of the state of Michigan versus Niquai Lamar Evans. And that is you again, Mr. Roach.
Good morning again, Your Honors. I appear unopposed this morning in this matter as well. I'm guessing it's the power of my persuasive brief writing. In this matter, Your Honors, I again would rely on the briefs presented. The only thing I want to touch on was issue 2, the sufficiency. And this is the charge that carries with it the 20-year minimum sentence that Mr. Evans is undergoing right now. There was no one that saw him carrying that bag of drugs that was found in the pickup truck. None of the officers saw it. There was no cameras on it. And when the bag was tested, there was no fingerprint or DNA evidence on it. I only bring it up because, again, that's the charge that is the greatest charge in this case, for which he is serving a 20-year minimum sentence. And, in light of the fact that there wasn't any direct evidence to that, unlike the other convictions, I thought I would make that a fact that the court should consider in its opinion. Other than that, Your Honors, I have nothing additional to add to it, and I'm happy to answer any questions that the panel might have.
No, I think I understand the arguments from the brief. Thank you.
So are you saying that circumstantial evidence alone cannot be sufficient?
I am not, Your Honors, but Your Honor, but there is an inference here that he was somehow the individual that did that, and there was nothing else linking it. And again, because of the duration of the sentence, I think that's something that should be looked at because we're basing it completely on an inference here and not any direct evidence.
Right, but he was running through that neighborhood, right?
He was, Your Honor, and in fact, Officer Buck did lose sight of him for some period of time. I acknowledge that as well, Your Honor. I just wanted to put that point before the court.
Okay, all right, all right. I don't think there are any other questions, so with that, that matter is submitted. Thank you again, Mr. Roach. All right, we'll move on to item number 3, docket number 367101, People of the State of Michigan versus Stefan Duran Delaney. And I believe this is another Zoom argument.
Okay. God,
right,
am I in?
Yes, good
Oh,
morning,
good morning.
Mr. Strauss. You're free to go ahead and make your argument.
Okay, good morning, everybody. Really, I generally would rely on my brief just to emphasize with the no-knock warrant that was issued, that was based on a brief conversation. The first part of as far as the searching the house for a drug operation, he had driven Miss Rittenauer at her request. She drove 2 hours from Indiana, as the court's aware, and she wanted drugs from him. And I guess the sex was in the mix as well when she drove up 2 hours from Indiana. He drove someplace else because he didn't have any drugs. And
Well,
Detective,
he didn't have any cocaine, right?
right, nothing to give her, right. I don't believe she mentioned that in the brief conversation, but in the 4 corners of the affidavit, he mentioned that they had to go there to see if he was distributing, manufacturing, distributing drugs. But just based on something that happened far away from the house at her request, I don't think that gives any basis for a no-knock raid on the house. And we cited some cases. This was not a controlled buy situation, but even in controlled buy situations, in the cases we cited, even one buy is not enough to substantiate a warrant. And here, there was no surveillance, nothing indicating that he was running a drug operation on the face of the affidavit. So it just seemed kind of like a fishing expedition, and he kind of bootstrapped that onto that. There was another case with an assault case, and somehow he, as much to his surprise, in the large police department, he noticed that he was being charged with an assault, and he said, well, they had to go to the house on that basis too, because I guess because weapons are movable, and because people generally regularly get rid of guns during offenses. But that was a shoddy basis, and it just seems like it was all a pretense to just do an investigation on a warrant when there's really no basis for it.
All right. I'm seeing no other.
No, I think I understand the position from the briefing. Yeah.
Okay, all right.
Thank you.
All right. With that, that matter is submitted, and we'll move on to item number 4. So don't go anywhere, Mr. Strauss. We're up on this one. 371033, People of the State of Michigan versus Kenyatta Andrew Michael Newbern. And we have Ms. Went in the courtroom today. So please go ahead.
Well, here I would just rest on my brief. If court has any questions, I'm here. Answer as best as I can.
Okay. Is there any-
No, I think the briefs lay it all
I
out.
see none. All right, Ms. Went.
Good morning, Your Honors. Katie Went with the Kent County Prosecutor's Office on behalf of the people. With respect to responding to Mr. Strauss's brief, I would rest on mine unless the court has any questions, but I do want to address the points in the standard 4 as well.
All right.
Okay. With respect to the standard 4, the first issue, since I didn't do a written response, just briefly want to touch on our position for the court. The first issue revolves around the music video filming. As discussed in my brief and the facts, this is highly relevant to the ultimate resolution of the offense because it shows what
Possession of a weapon.
correct. I wanted to give the court a couple sites, just in case, since I didn't do the briefing. People v. Hall, 433 Mish at 580 to 581. And People v. Houston, 261 Mish App, 463, a 2004 case. Both of these just supporting the argument that this is directly relevant. With respect to the cell phone search warrant, this was a little bit more difficult to parse out for me in reading the defendant's argument because he attaches two search warrants to his brief that are not the search warrant for the cell phone. I did obtain that from the detective, and so if the court wants to see it, I can file it for the court to look at. I do believe there's probable cause established in there. However, I don't think it matters for the court's resolution of the issue because this is an ineffective assistance of counsel claim, and we have to look to the prejudice that was established. And it's defendant's burden to establish that prejudice. So when we look to his argument, he points to two pieces of evidence that he says changed the outcome of trial. He points to the text messages between himself and Marquise Welch, which, as the facts established at trial, those came from Welch's cell phone. That's how we identified potentially defendant's involvement in this crime. So that didn't come from the search warrant. The other thing he points to is the geolocation analysis data. That came from the T-Mobile search warrant that he did attach to his brief. So neither of the pieces of data that he refers to in trying to establish prejudice actually came from this cell phone search warrant. That's at issue here. Now, when I looked to the record to figure out what did come from it, what was used at trial, all I could find was just the one still shot that the prosecutor admitted from his photos that showed him in possession of a Glock firearm. That's it. I can't find anything else that the prosecutor used that came from that exact cell phone search warrant. So regardless of what this warrant actually said, which I maintain that there was probable cause, this court can find under Strickland can just move to the prejudice prong and say defendant didn't establish prejudice here because he hasn't shown that his attorney's failure to object was there was a reasonable probability that that changed the outcome of trial.
Is that affidavit that you spoke about earlier admitted in the record?
The affidavit for the cell phone search warrant, I don't believe it was because it was never challenged under a motion to suppress. So I don't know that it ever made it to the trial court. But I can submit it for this court if the court would like to review it. I would be happy to go back to my office and do that today. Okay. Any further questions?
It was not part of the record. We'd need a motion to expand the record, which
Okay.
is probably too late at this point.
Yeah.
So
Okay. Thank you, Your
I
Honors.
don't think there are.
Thank you. Good to see you.
Thank you, Mr. Strauss, and thank you.
Okay, thank you. Have a good day.
That matter is submitted.
Okay.
All right, we're on to item number 5, docket number 370327, People of the State of Michigan versus Thaddeus Cortez Wilson. Live human beings, it's great.
Yeah.
All right, Mr. How is it pronounced?
Chasik, Your Honor.
Machasik?
Yes.
Okay, you may begin.
Good morning, Your Honor, and may it please this honorable court, Ryan Machasik appearing on behalf of Mr. Wilson. I will rest on the brief submitted, but I am happy to attempt to field any questions that the panel may have.
Yeah, I don't have.
Yep, nothing for me. I understand the position from the briefs.
Thank you, Your Honor.
All right, Mr. Blair?
Good morning, Your Honors. My name is Jonathan Blair. I'm from Allegan County, and as I discussed with co-counsel beforehand, I'm also going to rely on my brief unless the court has any questions.
I don't think that position has changed.
Thank you very much and have a good day.
All right. Thank you both. Your case is submitted. Item number 6, docket number 370437, People of the State of Michigan versus Russ Gregory Ball.
Morning, Your Honors.
Good morning, Ms. Owens.
May it please the court, I am Mary Owens on behalf of the appellant Ross Gregory Ball. And I'm largely going to rest on my brief, but I did want to touch on some points in our principal argument, that being that Mr. Ball's waiver of counsel was not equivocal and it was ineffective, and it's a structural error that requires automatic reversal. I cited all of the pertinent cases that I could find at the time of submitting my brief, and I haven't found anything recent to update it. But I think it's pretty clear that Mr. Ball wanted counsel. I mean, he started off, he had 3 or 4 attorneys at the first. Then he was going back and forth with the standby counsel, Mr. White. And he did say at times that there was one hearing where I agreed that arguably Judge Wilson finally elicited a true waiver from him. That would have been at the December 28th hearing, just before trial. But as I noted, the judge did not re-inquire at all until the 5th day of trial. And our Supreme Court has said very clearly that it's a structural error if you don't at least re-engage in some sort of colloquy regarding waiver of counsel, at the very least before jury instructions, or not jury instructions, jury selection. Our position, which would be a very broad position, is that the judge was required to engage in a new colloquy every day of trial. And the prosecution, of course, opposes that. And there is one Court of Appeals opinion, I think it's unpublished, the Dumas case that I cited, that says the trial judge must engage in a colloquy with the defendant on the first day of trial, but is not required to do that every single day.
Right.
So I think that's our we take the broad position, but we don't even think it's necessary to go there to rule on this particular issue, because the judge didn't do it at all during even before the jury was seated. And he was required at least to do it then. It's a structural error. It requires reversal. Now, the other thing that I wanted to point out was at one point during day 5 of trial, or day 6, when my client said, I've asked Attorney White to take over the defense and he won't do it because he says that the defense is unethical. And as the trial judge put it, well, he just doesn't want to put on the defense that you want to put on. And my client even said, well, we'll take that off the table. He still won't do it. So it's our position that as of then, he was essentially coerced into proceeding for the remaining 5-6 days of trial without counsel. I think I've set forth our position pretty fully in the brief. And so unless there are other questions, I will rest on my brief.
I think this seems like a challenging position for the court to be in. From the record that I see with, I guess with your client's sort of position on counsel, which fundamentally seemed to be, there's nobody I can trust but myself to do the job. And there's a lot of discussion. I think he recognizes he's not a lawyer, but also that he has not encountered a lawyer to do right by him in the courtroom. And there seemed to be a lot of discussions over the course of the case, including a trial, where the court is trying to figure out how to proceed here. And it seems to always come back to, there's nobody I can trust but me. So just practically speaking, what is the court supposed to do in that situation?
Well, first of all, Your Honor, and I agree with what you've said. And I believe that I even alluded to that in my brief, saying that his unequal repudiation or waiver of counsel was not unequivocal. I mean, and the trial judge was faced with that up until December 28th. That was the last pretrial hearing before trial, when we conceded that arguably Judge Wilson obtained a valid waiver. Okay. And I agree that my client was saying that there's no one else I can trust. I completely agree with that. He said that over and over again. However, and it is a difficult position for the court because it's black letter law. It's a structural error. If the judge doesn't repeat the colloquy at least of trial before jury selection. And then on day 6, my client probably realized that he'd gotten in over his head. And he says, yeah, I'll take the quote unquote unethical questions off the table, but he still won't represent me.
But did he quite say that? It seemed like
Yes,
he was
he did.
speaking in a more, I guess, obviously we have the record before, so we'll rely on that. But there seemed to be a more, I don't know if it's a sort of, I've talked to him and said, if I did this, would he do that? And, there's sort of conditional hypothetical gloss to sort of what he's speaking about.
Exactly, Judge, which means that whatever the status of his waiver up until that time became equivocal, right? He's saying, I'll do what you want. I'll take the medical off the table. Would you do it? And the judge did not even inquire of Attorney White saying, is it true you're going to refuse to represent him? So at that point, we think whatever remained of a valid waiver was extinguished. And it's a very challenging position for this court because it was a 12-day trial. But we don't think there's any other outcome. So unless there are other questions, I'm going to rest on my brief.
More for me. Thank you.
Okay, thank you.
Right.
Good morning. May it please the court, Matt Way from the Jackson County Prosecutor's Office on behalf of the people. Judge Mariani, I want to start with your kind of point, because what I kept thinking about when I was thinking about this case is if the court had basically required Mr. Ball to have counsel, there's zero doubt in my mind that we would be here on a denial of self-representation claim. And I think that would be a much stronger claim than this one is, given 2 points which I think make clear that Mr. Ball was unequivocal. And the first was at the December 28th hearing that Ms. Owens has referenced, where he says he would unequivocally would like to represent himself. I don't know how it gets much more clear than that. And then
During the jury trial, when he's making his opening statement.
yes, and he says it was a sign from God that his prior attorney had withdrawn so he could represent himself. It doesn't get any more. He does go into these moments where Mr. Ball is, I think you can tell from the record, he's a very argumentative person. He gets into these arguments, he gets into these kind of holes where he wants to talk about what happened in the past, who's against him, who's not, who's railroading him. But he always ends up getting to a place where, no, I want to represent myself. And I think that it's really that simple.
And what about the exchange mid-trial?
And I'd rely on the record for that. I don't have a clear memory of exactly what happened during that exchange. I think it was day 9. But my recollection is, again, Mr. Ball, he does say these things, but he eventually says like, no, I want to represent myself. But I would, certainly rely on what the record says for that part. As far as Judge Wilson not informing him of not complying with the court rule 6, I think it's 6, it's sub E, not sub D, but the requirement to continue to kind of warn him. We can see he clearly did not do that on the first day of trial, the second, third, and fourth days of trial. But as the Lane case that we cite in our brief very clearly says, that is subject to harmless error analysis. There's unpublished cases from this court as recently as this year saying the same thing. And I certainly think People v. King does not say anything about that. So People v. King does not change that analysis at all. Did that answer your question?
To some extent, I guess if understanding that this is, I'm not saying that this is this case, but hypothetically, everything is the same. We have a defendant who says in their opening argument, I'm representing myself. Mid-trial has some doubts and says, I don't think this is a good idea. I want a lawyer. What is the court's obligation there? Does that extinguish as the prior representation at the start of trial that this is the path that this defendant wants to go down for the purposes of his trial?
If you have a situation, and I don't think this is this case, but if you did have a situation where the defendant is like, I'm way in over my head. I need my standby attorney to step in and just take over. Then yes, I think that the court is under the obligation to do that under the case law. I don't think that's what Mr. Ball said, or I don't think really that's how it played out in this case, though.
And I guess, how do I know that?
I think everything he talks about, and the way he talks about Mr. White from pre-trial to middle of trial, how he's not helping him, he's not doing what he wants, he's not presenting, or he's not willing to present the defense he wants. I don't recall the exact exchange that Ms. Owens referenced. But I mean, there's a certain point and I don't recall what hearing it is, but prior to the trial where he doesn't even want Mr. White as standby counsel. He specifically names the attorney that he wants out of Lansing. because he wants to be able to pick his appointed attorney or his appointed standby counsel. The relationship between Mr. Ball and Mr. White was clearly very contentious, and I think especially when you look at the entirety of the record, it's clear that Mr. Ball did not ever specifically request, after the conversations took place, and when you get to the end of the conversation, he never specifically says, I need Mr. White to step in and take over because I just can't do this. No, I have not seen that in the record, my reading of it.
Okay, understood.
Any additional questions?
No, I mean, I think the point is made that he doesn't like the lawyer. He wants Clarence Darrow, but he's not gonna get Clarence Darrow. He can't get somebody from outside the county. And in the end, he says, I can only trust myself. So no matter how you accuse the lawyer of making faces, that there was a conspiracy, and it all comes down to, I don't trust this guy. So unequivocally, he says, I'm gonna represent myself.
Yeah, and he had 3 very good attorneys prior to this. It's not an unusual circumstance that you end up with people who just don't like their attorneys. They go through 3 or 4, and the judge finally has to, at some point, the judge has to say, I can't give you another one. You don't just get to pick and choose who your appointed attorney is.
Anyone
So-
can have a problem with 1, maybe 2, but when you're on your 4th, judges start to wonder what, maybe where the problem lies.
Yeah, certainly. And I know defense kind of frames the idea that I have to do this as kind of equivocation. I would just argue that that's just his reason for wanting to represent himself. It's not really equivocation.
Especially given the defense that he presented.
Absolutely, Your Honor. Thank you. We would just ask the court to affirm.
Rebuttal?
I'd like to address the point just brought up by Judge Kelly. And we mentioned this in our brief. Yes, he did have 3 prior attorneys, but they all withdrew, having nothing to do with a conflict. We put that in our brief. One attorney accepted a job at the Oakland County Prosecutor's Office. One had to withdraw due to a conflict. So if you check it out, Judge, and I can find it in my brief, and I outlined exactly where they had withdrawn.
No, if
Oh,
it's
it was on page 9.
if it's in the record, we'll find it.
I just said, so it's not fair to say that he's, had to get rid of all of these other prior attorneys because he couldn't get along with them. That's not the fact.
Apparently, nobody in that county is good enough for him.
Well, I agree with you.
Yeah.
When I agree with, and we conceded this in our brief, the judge is not required to shop around for an attorney of his pleasing. I agreed with that. So those are the only 2 points I wanted to make in rebuttal, and I appreciate it. Thank you so much.
Thank you, counsel.
Thank you both. The matter is submitted. And we're now at our 11 o'clock call has,
There's a couple of people coming in.
okay.
Representatives for the appellant.
All right. So it is clearly not 11 o'clock. So we will take a brief recess. Morning. Yeah. Good morning. All right, nobody's going to respond to that. All right. Well, as you can see, we're on the 11 o'clock call. And I am going to repeat some of our rules. I think we have arguments left to this morning where there are 2 sides on the case. You're free to split up your time if there's more than 2 attorneys on the one side. And if you'd like, I'll keep your time for you. So with that, I'm going to call item number 7, docket number 367554, Harbor Isles Marine LLC versus J. Chodak. Mr. Egan? You have half an hour, in case,
Hopefully don't need it.
right, in case you didn't hear what I said.
I did hear it.
Okay, all right. Yeah, we're pretty familiar with the facts and the law, and if you could just direct our attention to those things that you believe are legal errors or factual errors by the court, that would be terrific.
I will. And I appreciate, thanks for the opportunity to be here. Essentially, we're dealing with an involuntary dismissal during a trial of claims against moorings, and then two summary dispositions against Mr. Gould and the St. Joe Isle Yacht Club. I want to first of all deal with moorings. I think everybody understands there's this 11-acre piece of land. It's got showers, other facilities on it. There's shared recreation agreements where the three marinas that abut my client's property get to use those facilities. My client has expenses, taxes, maintenance, et cetera. They're supposed to be getting payments from the three abutting marina condominiums where their people are using these facilities. Scott Sinar was the witness that we presented at the trial. Mr. Sinar's 37 years lawyer, real estate developer. He's developed condominiums as a lawyer. He's intimately familiar with real estate documents. He did the due diligence when Harbor Isles acquired the property. He wanted to testify, first of all, that the property on which these facilities lies is his property. And he had a survey which he marked up. The judge said he didn't do the blue part. No, he testified he did the red, which was the overall parcel. And then in blue was the area covered by the shared rec agreement.
Counsel, it seems like there's maybe two issues that are related but distinct. One is, what is the property, and the other is who owns it, right?
Yes.
And I guess I understand that the point of the dispute about testifying about what the exact property is at issue, but the chain of title, it seems to have been not complete in the evidence that was presented, and that seemed to be a independently sufficient basis for the court's ruling. And why I understand your position that the agreement runs with the land, but you still kind of have to show that you've acquired the interest in the land that to which that right would attach. So why is this gap in title not dispositive?
Because we simply do own the property. We got a quitclaim deed. There was earlier a sheriff's deed.
Right, so you have a quitclaim deed. So you have whatever that person had, but we don't know what that person had, or we don't know what Mickler had, right? That's the entity. There's nothing to tell us what they had.
But the court allowed Mr. Sinar to testify on our land. We have these facilities.
But that's fine, but it did not seem like there was any proofs put in that what they got from Mickler was those things.
No, he explained, he looked at the surveys, he looked at the legal description. And by the way, nobody had ever contested up to this day at this trial. The objection was he couldn't testify to this without being a licensed surveyor. That was the actual objection. And in fact, they had already, there was an injunction entered in which they alleged my client was the other side of the property. This was on this ingress egress thing. So we were treated as being the owners of the property in question at certain times, but at trial, suddenly Mr. Sinar couldn't say, I've looked at the master deed. I've looked at the rec agreement. We got this. And by the way, as the judge said during the trial, it's in our reply brief, the judge asked Ms. Lockman, well, Mr. Sinar, who testified, he was allowed to testify. These are on our property at 341. By the way, we're paying the taxes on this property. Nobody else is. The judge at length then said to Ms. Lockman, well, are there any other pools, laundry, fish cleaning stations on the property? There aren't any. The only facilities that they're using are these facilities. And they filed motion for summary disposition stating we were the owner of the property. Well, suddenly at trial, Mr. Sinar, who knows what he's doing, can't testify and say, here, I've looked at the survey, I've marked it up, here's what we owe, here's what we own. And the fact is, we're paying taxes, nobody else is. Then who owns this property? It doesn't make any sense.
But I think that you're right. It is a question, right? Who owns it? And it seems like that's part of your client's proofs. Right? It's part of your affirmative proofs to show that you are the successor. And I guess it did not seem as though there was, we have what we have in terms of the deeds and the chain of title. And it did not seem like there was a point where there was a fuller record about what those documents would have been, where those gaps would have been filled. Here's what Mickler got, and we have that document to offer to you.
But for example, Mooring filed a motion for summary in June 22. Historically, the use of the property was on Harbor Isles property, which borders on there. I mean, that was in the motion. So they've always taken the position that we were the property owner. They got in a permanent injunction on the ingress egress easement suing Harbor Isles, not this fictional owner out there. So why?
I mean, Harbor Isles was the one that was taking the action that needed to stop, right?
Yes.
So that would be the entity you would sue, regardless of whether they actually had valid ownership. You would still have to say, this is the entity that needs to be enjoined from interfering with our access rights.
But they said regarding this ingress egress agreement in their pleadings, they said we were the party to the ingress egress agreement. Well, if we're not the owner, we're not the party. We were the successor to the party to that ingress egress. We can't be the owner of the property when they want us to be, and then not be when we're trying to simply have them pay their fair share of the expenses we've undertaken. Now, I believe under basic law, I was taught that if you get, you got a 50-50 point, if you're over 50%, you've carried your burden, and then the other side tries to get you back over carrying your burden of proof. There was a significant amount of testimony in the documents from Mr. Sinar. They were entitled then, okay, on their side of the case, show that we don't own the property. But I think we did enough to carry the burden of proof, and the case shouldn't have been subject to an involuntary dismissal. And note, the court, and this is important, made it clear all the rulings on this were legal rulings. It had no factual findings. So you can look at it de novo. But I mean, you have a man familiar with the property. He says, I've walked the property. I've looked at it. I've done the due diligence. This is our property. Okay, so you don't know whether this foot over in this corner, there's no dispute that Harbor Isles owns these facilities. They don't dispute it. They've been using them. We get sued if they don't like whether we're giving them access to parking lots and other things. And then all of a sudden the court decided, even though it issued an injunction treating us as the owner, they filed a motion for summary claiming we're the party, the owner and the party. Now all of a sudden, we're not the owner, and I think we carried our burden of proof. In any event, as we said, if it runs with the land, we have an interest in the land. Nobody disputes that we have an interest in the land. There's nobody else. We're paying the property taxes. The quitclaim deed had the tax ID numbers on them. Berrien County has an interesting thing where you can essentially get a satellite image and look at the parcel ID numbers, and Mr. Sinar testified he did, and those tax parcels were on their 11-acre share of the land. So we just believe it's completely inconsistent for the court
to let him testify, these facilities are on Harbor Isles land, and then dismiss the case because we don't have a deed. He had a deed showing some ownership. Now, if there's a sheriff's deed, we can't get a warranty deed after there's been a sheriff's deed. So what's a party supposed to get? If it can't get a warranty deed, then it doesn't have any rights to the property. They've been using our facilities. We've been paying all the expenses. They've never disputed that before that you don't own, we owe the money to somebody else. And essentially sort of what the court was saying, if we don't own this, well, who does? But we've been literally denied our day in court because the court decided because Mr. Sinar wasn't a surveyor, he can't testify. I was an associate out of law school, was in a large real estate closing. I was locating easements on big blueprint drawings of land. Mr. Sinar is perfectly capable of saying, okay, you go 400 feet down this line, you go 300 feet down this line and say, yeah, that's our property. So we think we carried our burden pretty effectively to get to that point. One other. As I said, the chain of title really isn't the issue. It runs with the land. There's no dispute that we have this property. We're paying taxes on it. And the court let him testify that these are our facilities. And then the court asked Ms. Lockman, are there any other sets of these facilities other than on the Harbor Isles plot of land? And there aren't any. So I think we did enough to carry our burden of proof, and the trial should have been allowed to continue. As a result, the court never got into the damages for breach of the shared rec agreement because she said she really couldn't, having found that we didn't show the chain of title. But though that needs to be remanded, so we go back and finish the trial because we had about $180,000 of shared rec expenses to be apportioned among the various groups. The court did hold that the shared rec agreement ran with the land. I think it's obvious, but she did make that ruling. That's on Appendix 111. So the court made the ruling, it ran with the land. We have an interest in the land. We ought to be able to enforce those restrictions where appropriate. And in this case, we're the one to do it. And as I said, we're paying for everything. Do you have any other questions on this issue?
No, not for me. I think I understand your position.
Okay. Let's see, it was also. So we believe that running with the land covers this. We viewed the contradictory that there's motions and injunctions filed claiming we're the owner of the land, but suddenly we're not. The other issues on appeal, first of all, the St. George Isle Yacht Club got a motion for summary disposition. The count that bothers me is the breach of contract one. There was also similar recreation agreement that they were the party to, it's the successor in interest to, and they all of a sudden notified us that they had terminated that agreement. We filed a complaint that I think was pretty specific. If the courts look at paragraphs 104 to 109, which are Appendix 371 to 374, they basically plead the existence of this agreement. We also they claim they terminated the agreement, but the agreement to modify it required everybody to sign. And also in paragraphs 111, 112, and 119, we pleaded they didn't pay and they couldn't terminate the agreement. The court said it wasn't clear from the complaint how they breached. The complaint was very clear. They terminated an agreement they didn't have the right to terminate. We pleaded they couldn't terminate it specifically, and we said then they didn't pay us. This was essentially a C8 motion, and you got to accept the well-pleaded allegations and the complaint is true. The complaint didn't hide. It didn't just say, we have a contract they breached, give us money. It explained why they breached it. They could not terminate it. And if you look paragraph 22 of that agreement, they could terminate only if they built separate facilities only for the St. Joe Isle Yacht Club, which had not been built. So you can't terminate. It'd be different if you set them up and you said, now we have our own pool facility, so their people are still using our facilities, and the court should have never granted that motion for summary. The last one relates to Mr. Gould. The court entered summary disposition from them. There was a breach of fiduciary duty claim. Now, the court ruled correctly that Mr. Gould did not owe Harbor Isles fiduciary duties sitting on the board of his condo association, because he did not owe us for that purpose. But as the complaint sped out, he sat on a committee that administered the shared recreation money that was being collected from the various associations. He essentially, and this is pleaded, and there's an affidavit also that was filed, that he was essentially not sharing information with the other committee members. Mr. Sinar was on that committee. He had control of the bank account. If Mr. Sinar asked for a copy of the bank statement, it was redacted. So Mr. Gould essentially exercised complete control, in our view, made himself essentially the trustee of those funds by not sharing control of the funds with the other people on the committee. I submit that's a fiduciary obligation as sitting on that committee. It had nothing to do with him sitting on that association board. That board put him on this committee, and it's a special relationship of trust and confidence that creates a fiduciary obligation, so that claim shouldn't have been dismissed. Anything else? I don't have, unless you have questions.
No, I don't.
No, I think I understand. Thank you.
I see none, and you have plenty of time for rebuttal. Have you worked out amongst yourselves who's going to argue, and have you worked out amongst yourselves who's going to argue? All right.
Morning, Your Honors. May it please the court, Stephen Smith on behalf of defendant appellee St. Joe Isle Yacht Club. This is, the appeal is largely, there were 4 counts against my client in the trial court. This is largely an appeal of the summary disposition granted under C8 as to counts 1 and 3, the declaratory judgment and the breach of deed and bylaws. The summary disposition was granted largely because the judge in the trial court determined that the extremely extensive complaint filed by the plaintiffs had not met the requirements of MCR 2.111. It was not well pleaded. I note both the appellant's brief and our brief quote extensively from the trial court's transcript, and you can tangibly see the judge struggling to really explain just how utterly void the complaint was of a clearly pled claim against St. Joe Isle Yacht Club, and thus concluded it was a clear failure to meet MCR 2.111. We believe the trial court did not err in making that determination and granting summary disposition under C8. In their brief, the appellants quote from my client's motion for summary disposition. As we note in our brief, that is, as this court has ruled in Village of Diamonddale versus Grapel 240 Mishap 553 in the year 2000, a summary disposition motion is not a responsive pleading for purposes of determining a C8 review. The court looks to complaints, it looks to cross claims and answers and such. In addition, I would note that the appellants in their brief in talking about what my client's summary disposition motion said, frankly misread the asserted facts, and they erroneously conflate 2 very distinct entities. The one of which appellant Harbor Isle Marine is the current day successor, and the one of which my client is the current day successor to a condominium developer. The reply brief that we received, largely a self-serving summary of the complaint, but the trial court read the whole complaint. It reviewed the whole complaint. I note, counsel mentions, well, if you look at, 100, 104, and then you jump out to 370, that's the struggle that the trial court was dealing with, trying to find in this very large complaint.
Well, so what piece was, I mean, I think there's, it seemed like in the reply brief, in the briefing before us is when the real argument about the termination was made. And, we can talk about whether that is the right way to do it. But just taking that on its face, what's missing in the termination, in a breach based on termination in terms of stating the claim?
Essentially, it's the interpretation of the agreement. There's an interpretation. Appellants said since the beginning, well, you read that language about being able to terminate. Either it has to be a mutual decision, or we have to have facilities in place. We simply argued to the court that simply isn't the case. We don't have to have consent. And the requirement for building facilities, we had given notice, we are building facilities. Those facilities exist now. There's certainly no language that says, as specifically as counsel says, you've got to have them in place and be having people walking in and out of the restroom before you can terminate the agreement. That simply wasn't the language of the agreement. So notice was properly given. Notably, appellants don't argue the recordation issue, which was one of the issues that was dismissed under C10. So that the court considered the disputes as to what the agreement said, and that's how you terminate, but made those decisions based on what it had in front of it. What other questions may I answer? Okay, thank you.
Thank you, Sarah Lockman here on behalf of Maureen's Association and the directors. I apologize. I thought I was on time, but this apparently started early, so there might be some things that were addressed by counsel that I might not have heard. But what I did hear sounded like counsel raising new allegations of fact that don't have supporting evidence here, and certainly not at the trial court. For example, to the extent he's talking about what is going on currently with the property, that was not anything at issue on the trial court because it was in the past, and it's not here before you today. I will note that within 14 days or so of that trial being concluded, while filing this appeal, they also filed a brand new lawsuit. So we actually go to trial again in 10 days or so with Harbor Isle, all related to these items, many of these items now. I will also note that it is two different counsels, two different law firms. So the trial counsel that I have there is not the same counsel who is handling the appeal. And it sounds like there is not necessarily complete agreement between all the different positions being taken, which is very challenging for Maureen's. But the appeal is narrow. It is not a retrial of the trial that already happened or the trial that is getting ready to happen in a handful of days. They have asked for specific questions to be reviewed, and there are specific burdens that have to be met and standards of review that get applied. But it is not simply reconsidering the case in its entirety. What the issues raised on appeal addressed were evidentiary questions, except that what did not get addressed is that the evidence wasn't excluded. Objections were made, but by and large, anything that was complained about was actually admitted ultimately into evidence, and then lines of questioning just simply abandoned. What they admitted into evidence was a quit claim deed, and that quit claim deed actually excludes, so just from a plain reading, the second page of the deed states, also accepting therefrom that portion platted as Harbor Isle Moorings, a condominium, according to the master deed recorded in Liber 62 of condominiums, page 1, on and on. And that is Maureen's Association that gets accepted. And so there's no question, just from a plain reading, that the quit claim deed did not transfer that property to Harbor Isle.
Well, just to be clear, Counsel, you're saying that the quitclaim deed clearly did not transfer the property on which your client is located.
Correct, Your Honor.
Okay, but that doesn't seem to be the dispute, right? The dispute seemed to be to transfer the property on which the shared facilities are on, correct?
Well, except that the property described in the shared rec facilities is Maureen's property.
The description in there.
Yes.
Right, yes, yeah, I remember this dispute and.
Yes, well, it's quite curious, right? Because the shared rec facilities, the description in the shared usage agreement, or I think they're two different,
Yeah.
they're not all called the same thing. So for moorings, the usage agreement, it says moorings has the right to use property described at this exhibit. And that property that is described is moorings property. And that property is excluded in that quitclaim deed from any property that Harbor Isle claims that they owned. But also important to the involuntary dismissal was that a quitclaim deed only transfers whatever rights and ownership interest the grantor has. And plaintiff, appellant, never established what rights the grantor had. It was not the original developer listed as the grantor. It was not even the known successor developer listed as a grantor. I can give a quitclaim deed to the White House. It doesn't mean it's any good. They did not establish any chain of title.
What about to counsel's point that up until this point, there didn't seem to be a dispute about their ownership of the land. They point to prior filings by your client in connection with the access easement representing that, Harbor Isles is the successor to Slayball.
There was dispute over that to the extent that we denied they had the right to enforce it. But counsel simply, in my opinion, ignored it, frankly, as they're doing again in this upcoming trial. There were a lot of different disputes. So to the extent that Harbor Isle physically locked out moorings from its property, there was actually an individual trapped on his boat over an entire weekend because he was locked in. So not only did they lock people out, they also locked somebody in. They could not get in or out of the gate. No dispute that Harbor Isle, the plaintiff appellant here, is the entity that locked them out. But whether or not they had the right to enforce the usage agreement, which is separate than the access easement, two separate documents, access easement, not even part of Maureen's master deed. It is a separate, independent, standalone document. Appellant was regularly conflating them, but they weren't to be conflated. And we didn't dispute that they were the ones preventing access to the road. But we did dispute that they had a right to enforce the usage agreement. We continue to dispute that. And in fact, it's a violation of the Condominium Act that they even have attempted to enforce it and collected money on it. But the trial court is waiting on your decision here to decide how to address that violation of the Condominium Act.
You understand?
I just want to also note that this would require a finding of clear error as to the evidentiary issues raised, and all of the issues were very thoroughly discussed at the trial court level. The objections, again, were often not sustained, so that the evidence was in fact admitted. Scott Sinar was, certainly not qualified to testify as an expert, but ultimately, whether he was or wasn't doesn't matter because he simply never testified to the critical salient issues that would ensure that there was a proper chain of title so that a quitclaim deed actually conveyed anything that would allow them to enforce that usage agreement. There was no assignment of that usage agreement, and simply purchasing the property even if they had, didn't necessarily give them those rights as they're claiming. But again, most importantly, they never established that they were able to take those interests through any sort of proper chain of title. They instead just simply said, here's a deed that accepts out Maureen's property and accepts out the property that is described in the usage agreement itself. Thank you. Any other questions?
For me.
See none. Thank you.
Good morning, and may it please the court, Andrew McInnes here on behalf of defendant appellee David Gould, pursuant to the court's September 30th order, Your Honor. You was invited to answer any questions that you may have. I'm happy to answer any questions or offer a very, very brief rebuttal with respect to counsel's arguments and an oral argument or reply, or answer any questions.
I don't have any myself.
You're not for me. I think I understand your position.
From the briefing.
Thank you, Your
So
Honor.
thank you. Thank you for appearing. Appreciate it. All right, rebuttal?
Just a little bit.
I thought you might.
Just regarding what Mr. Smith said, just look at the complaint. The complaint pleads the contract, explains why it was breached and that there's damages. If the court was struggling to understand the breach, then the court needed to look at that complaint a little more carefully. It's stated it pretty clearly in the paragraphs that I cited. Ms. Lockman claims that we made new allegations of fact. I don't remember anything discussed in my briefs or otherwise here today that isn't in the record attached to the briefs in this case that were before Judge Howard. I don't know anything about a new lawsuit. I'm not involved in it. I don't even know what it's about or what it is, but she's talking at length about it. She's the one attempting to bring up things not in the record as if they matter. She says the evidence was not excluded. Technically, the deed was let in. The judge did not let in the marked up portion of that survey. But letting the deed in doesn't mean that everything got in. She still excluded Mr. Sinar's testimony where he was saying this reflects the land we own. That she did exclude. So it's technically correct. The deed came in, but she didn't let us do anything with it. She then starts talking about the shared recreation agreement covers their property. That argument wasn't raised at trial and it wasn't raised in anywhere in their briefs. That's a new argument. By the way, so she's saying if you look at the shared rec agreement, it's actually describing Mooring's property. Well, that's odd. She's not a surveyor. She doesn't even claim to have Mr. Sinar's 37 years of experience in real estate, but she's here asserting to you that the shared rec agreement covers their property they own. She has no basis for that, and that's never been raised in this appeal at any point up till now. But once again, she's not a surveyor, so she can talk about what's included in property, but Mr. Sinar wasn't allowed to do at the trial. That's just patently unfair. She said that they were disputing the right of Harbor Isles to enforce this ingress egress agreement. And then, by the way, she started talking about an occasion on a weekend when they didn't have access to the property. That again is not part of this record. That allegation occurred after this appeal was filed. I know they filed motions in that case. I did not handle those motions. I was not involved. So here we are again. We're on an appeal on a stated record. We're hearing about something that happened over a weekend when people couldn't get access to a parking lot. It's not in this record. It was afterwards, and I don't know what happened with it. I passed it along to my co-counsel and the client, and they presumably dealt with it. But She's the one trying to clutter up this record with new facts, evidence that isn't evidence, and assertions regarding what's covered by the SRA. Mr. Sinar was eminently qualified to talk about what he owned. She said we have to show clear error. I disagree. The judge went out of her way to say I'm not deciding anything on factual basis or credibility or anything. This is a de novo review on the law, and I'm asking you to apply the law to the facts that we attempted to put in and reverse these rulings. Do you have anything else? Thank you very much.
Thank you all for appearing, and this matter is submitted. I'm going to call our last case. Item number 8, docket. It's a consolidated case, so the docket numbers are 371-659 and 372-399. Richard J. Vanderkolk versus Kayla Rose Benchoof.
Good morning, Your Honors. My name is Richard Vanderkolk, and I'm the plaintiff, the appellant in this case. Because this is consolidated, is it the preference of the
It is
panel?
still a half an hour.
Okay, and so we discuss them both at the same time.
You can, yes,
My preference, very good.
feel free to do that.
I'd like to go in reverse then, if I might, just briefly,
You
regarding
want to
this.
turn to the attorney's fees first?
The sanctions case, yes, 371-659.
All right.
And it's just as a matter of logic. On the sanctions issue, logically, it follows that if this court agrees that I stated valid grounds for defamation and provided facts to support these grounds, the case is not frivolous and sanctions are not warranted.
Right.
And because of that, I'll just focus on the main case, 2399. I want to emphasize for starters that I believed and continue to believe that the appellee's statements in this defamation case were unprivileged, malicious, and at the very least made with reckless disregard of the truth. Moreover, as cited in my amended complaint and affidavit, statements made to third parties lacking a shared interest with the appellee and myself contained no legitimate interest in this matter, and that constituted actual malice. Appellee claims that her statements cannot have been defamatory because she was just repeating information received by Mr. Villani. I have cited legal authority in my brief to the effect that repeating defamatory materials, unless privileged and without malice, constitutes defamation. I couldn't find a Michigan case, particularly on repeating defamation, so there was some national case nationwide, Cianci versus New York Times, a restatement of tort second. It's also argued in my briefs that I suffered special harm, justifying my defamation claim under MCL 600-2911. I've alleged and presented evidence my reputation has been damaged in the community with the school for those false and defamatory comments by the appellee. I further refute in my reply brief, the clear and convincing evidence is not required as there's no public figure involved. I cite statute MCL 600-2911 and the Kefkin case to that effect. I also point out in my reply brief, that is, that the appellee's failure to investigate Mr. Villani's false allegations constituted purposeful avoidance of the truth by failing to look into the validity of the expressed threats. The things that she would have known on their face would have been false. I pointed out in my affidavit in opposition to summary disposition of the numerous implausible and even impossible threats repeated by Ms. Benshoff, the appellee. to the extent that both a reasonable person and the appellee with her own special unique knowledge would know them to be false on their face. And finally, on the merits, as argued in my reply brief, I should be granted the right to amend my pleadings under MCR 2-118A2 to more specifically indicate the third parties to whom defamatory statements were made. It was referenced in the affidavit in opposition to motion for summary disposition. And in the amended complaint, it mentions the other parties. And with that, I will reserve time and take any questions.
No questions from me.
I see no questions, so you have plenty of time for rebuttal.
Thank you, and may it please the court, Tim Monsma on behalf of the appellee. I know you've read the briefing, so I'll try to be as brief as I can. First is maybe a threshold matter. We do make a procedural argument that the merits have not been preserved, and that is to say that his appeal, according to his claim of appeal, is on the denial of the motion for reconsideration and then on the denial of leave to amend. I'm happy to address the merits if the court would like, but that was kind of our threshold response on the brief.
Right, I don't think that is correct.
And I'm happy to talk
please
about the
go
merits.
ahead
We
because
briefed them as well,
right,
so.
the reconsideration order is the final order, and then you can challenge anything that occurred before that, so.
I appreciate that, Your Honor. So just very briefly, the court dismissed the defamation claim under C8 and C7, stating either that the statements were verifiably true. For example, the first statement that's at issue, she reported, I received information from an associate of my ex-husband. That was true. That's literally true. It's in the text messages in the record. So that's an example. The court said correctly, in my view, that as a matter of law, that cannot be defamatory. The three others, I believe there were 4 total at issue because many of the statements simply didn't involve my client. So they obviously can't be defamatory, at least not as to her. The court held simply that they weren't defamatory as a matter of law, and that is a threshold question. Things like explaining why her daughter wasn't in school because we have some concerns about how he might react. That was not only true, but it's also just not defamatory. It's simply relating background on why her daughter wasn't going to be there. So all of those reasons I think were correct. In addition, in the context of this case, the defamatory statements were allegedly made to supervisors at my client's children's school. And the court, as an additional basis for dismissing, said those are protected by a qualified privilege. And as the court is aware, once the privilege applies, the burden shifts to the plaintiff to show malice. And the court held correctly there was no actual evidence of malice other than maybe some arguments that he made. So for each of those reasons, we would ask that the court be affirmed on the defamation count. If the court has any questions on that count, I'm happy to answer them. Otherwise, I can move on to the abuse of process claim.
I think you can move on.
On the abuse of process claim, the court again correctly found under C10 that there was no abuse of process. In fact, the act of going to get a PPO successfully is exactly what the process is designed for. So by definition, there's no abuse. And as the court is very familiar with the law, abuse of process requires something after the process is initiated, not the mere fact of initiating the process. And again, the trial court held correctly. That's exactly what a PPO is for. There's no abuse. It's just a utilization. And because there's no ulterior motive, there can be no corresponding act, which is also a requirement to sustain an abuse of process claim. So for each of those reasons, we would also ask that the court be affirmed on the abuse of process claim. On the amendment issue, and I'm happy to answer questions on the abuse of process claim too. But on the amendment issue, that's of course an abuse of discretion, and he essentially refiled the same complaint that had already been dismissed. Now, Judge Hulsing, I don't think used the word futility, but I think that's what he was getting at is you just refiled the same complaint that I already held was defective. So I think in his words, there was nothing legally consequential about that. That's an abuse of discretion question. He had the opportunity to file an amendment. He had that right under the rules. He simply repackaged the exact same complaint essentially and refiled it. So we would respectfully submit it's not an abuse of discretion on those facts to deny leave to amend. I'm happy. I think I heard Your Honor say you wanted to hear about the sanctions issue as well. Otherwise, I'm happy to hold off.
It's your
All right,
time.
I'll just
You
briefly
can
touch on
do
that then.
whatever you want.
So the circuit court correctly dismissed the complaint, and then he went on to say, not only is this complaint meritless, but it's frivolous. And under the statute, of course, we all know the three grounds for finding that a filing is frivolous. The purpose is to harass, no basis to believe facts are true, and devoid of arguable legal merit. Each of those was present here. The court thoughtfully analyzed the grounds for finding that it was frivolous, leading with his own email where he says, basically, I'm going to tie you up in litigation for years and years and years. And in this context, we're dealing with an ex-husband and an ex-wife. I think the court appropriately took that into account as well. He took into account specifically, and this is in his opinion, the comments at the PPO hearing, or in connection with the PPO hearing, that her concerns were understandable. In other words, her statements about those concerns were not defamatory. They were, in his words, understandable. So the court took that into account. He took into account the intentional, partial and misleading quotes of those texts. I think the best example is the March 6th text. That's the one where she's talking about, I heard from an associate of my husband that he's threatening us. Well, in his complaint, he just quoted the part about he's threatening us. And that, of course, takes out the critical context about why she's reaching out because someone approached her. Then that was true. So the circuit court said that's additional evidence of an improper purpose. And then he looked at the briefing itself. There was one statement in particular where he essentially blames his ex-wife for the suicide of this former affiliate.
Associate.
And he says basically she should carry that with her for the rest of her life. Now, I'm not suggesting for a minute that we can't advocate in briefings. That's what we do. But the court used that as one more piece of evidence. And I think in Judge Hulsing's words, it was cruel, boorish, and irrelevant. And so he did what judges are supposed to do. He looked at all of the circumstances. He found that all three of those factors applied, and he found that the complaint was frivolous. Now, I believe that's an abuse of discretion standard. We all know that's a high standard. He wrote a very thoughtful opinion in my view in terms of how he came to that conclusion. So we would ask that that be affirmed. And then he also did, as he's required to do, a very detailed Purgu analysis. I mean, he went through all of the factors. He based it on the economics of loss survey that we're all familiar with. In some cases, he made downward adjustments. My colleague, one of our newer associates, was working on the file, and for her, he said a downward departure is appropriate. He took into account the hours that we spent on the file respectively, and he found that that was a reasonable job. And then he went through all of the Purgu factors. Not all of them apply here, but I think I counted 5 or so that do apply, and he specifically addressed those and came to a number based on the fees that we submitted. That's exactly how it's supposed to work. He came to a finding that a $22,000 and change award was reasonable under the circumstances, and that's an abuse of discretion standard as well that we would ask you uphold. If the court has any questions, I'm happy to answer them. Otherwise, I will rest on the brief.
None for me.
Thank you.
Rebuttal?
Opposing counsel touched on something that, as I try to reverse engineer how it became this way in terms of the trial court's order, he mentioned the factor of considering the fact that there's an ex-husband and ex-wife dynamic, family dynamic. And that has been, I think, one of the primary problems. If you go to Exhibit D, which is the transcript, May 3rd, 2024, opposing counsel asked the judge in open court if he can speak with the judge off the record. And just before that, he states, plaintiff, myself, clearly wants to relitigate his divorce. And, you know, the verbal hand waving basically says this is an open and shut case. And as he just demonstrated, it's not quite open and shut, is it? Because if you have scores of pages of legal analysis trying to figure out exactly what shared interest is and what happened and so forth. But the judge did note that there were not at the court disputed facts. So it's a matter of interpreting those facts. And counsel has said that the amended complaint, for example, was a new version of itself, very similar to the last version. That couldn't be further from the truth. That amended complaint contained references to other third parties, which would have had no shared interest whatsoever to the qualified privilege that was acquired allegedly with a school. Now, I think that that privilege is overcome by showing the actual malice of Ms. Benshoff. And I think that both the original complaint and the amended complaint demonstrate that what she knew going into that ex parte request and communication of the school, she knew to be false. And so if you know something to be false and or even a lower standard acting with reckless disregard of the truth, there is no privilege. And, in the brief, we've gone through the index of authorities for that. So on the one hand, on the merits, the actual facts of both the original complaint and the amended were not properly taken into account, were not weighted in trying to discern what actual malice looked like. And then how the amended complaint was handled, it was just discretionary thrown out. There was no vetting. There was no opportunity for another summary disposition, no hearing and so on. And I don't know how you can possibly arrive at that conclusion. And I don't know how it is that we allow this idea that, okay, there's a distaste, with torts between family members. That doesn't mean it doesn't apply to family members. If it means anything, it means we know each other pretty well. So you're trying to figure out what the special knowledge is for those who are communicating, in this case, false and defamatory communication. So, so the amended complaint was not handled properly by the trial court. It was dismissed, and I go in detail on this with the brief. It was dismissed without proper vetting. It did not take consideration the other third parties, which there were several, and they were listed in my affidavit attached to that amended complaint. So what remains? A number of the items that were listed in the decision, going through sentence by sentence, were of course true and irrelevant to my case. So I don't have any question about that, describing my daughter in a certain situation or time of day. The issue wasn't ever about whether the statements Ms. Benshoff heard were true and communicated, that what she heard, is whether she knew them to be false. That was always the issue. And the examples that counsel brought up relative to the out of context email or out of context text message, that's all that was. And that was just mischaracterized a moment ago by saying that I was going to keep her tied up in litigation. That's not what I said. I said there'll be litigation for years if we don't get this type of thing resolved, because this is ongoing to this day with my interaction with the school. I can't, be a substitute teacher there, for example, and other things that are sort of swept under the rug. Okay. So there was no ulterior purpose. There was cherry picking in that final report, that final order. And I think that cherry picking and reversal of characterization is due to the distaste that the trial court seemed to have had for ex-marital partners engaged in civil litigation. Any questions?
For me. All right. Thank you both for coming, and this matter is submitted, and that concludes our case call for today.